Very good evening. Welcome to the February 2024 Labourlaw monthly update. These would be the different segments that we would be covering today. And of course, we have the knowledge corner as the last segment, where we have already been trying to cover the topic of retrenchment. And today the topic is going to be on retrenchment compensation. So as part of the law of retrenchment, we'll be looking at the compensation aspect, like how do you calculate the retrenchment compensation payable to employees? Would it only be basic and DNS elements to be reckoned, or should it be the gross pay to be reckoned? And these are things that we would be covering today in the knowledge quarter at the last segment. With that, we start our first segment, amendments and ordinance. We have just one change to the Rights of Persons with Disabilities Rules 2024, where the government, as part of the Act, has been bringing in guidelines on accessibility rules for different sectors. And this time they brought it for the port. They've already brought in for hospitals and offices. And now accessibility, what should be done for persons with disabilities, has been brought about for the port sector in this month. Moving on to circulars and notifications, we start with the lighter side on this aspect. Something from the Assam Shops and Establishments Act 1971. Can anyone guess how many days of holidays is provided under the Assam Shops and Establishments Act? You can take a wild guess and just put it in the chat box. Quite a few of them say it is 7 and 10, but you're nowhere near. These are the number of holidays that's being provided under the Assam Shops and Establishments Act. So, but thankfully now the government at last says we are suspending all these. And so there is a circular by which says that the shops will remain open for all 70 days, and the employees, there's no requirement to close down the shops for these nearly 70 days of festival holidays. This is something is quite worrying, where the ESI has said that in their portal, the details of there seems to be some problem with our slide. Details of defaulting employees should be updated in the ESI portal. So whenever there is going to be any default, then the details of the defaulting employers would be updated once a C18 notice is issued to them. The ESI has also issued a circular where it has mandated that employers should hand over to the employees the e-pension cards that they are giving now to identify the employees. So these cards should be printed and handed over to the employees. As employers, once these cards are made available, you may need to print it out and hand it over and take an acknowledgement for having handed it over to the employees. The permanent disability benefit as well as the disability benefit under the ESI Act was enhanced from 1/8/22 in respect of disablement or death prior to 31/12/21. In many cases, they found that this enhancement has not happened and the arrears has not been paid. So they have called upon their own field officers to ensure that the enhancement is done and the payments are sent to the beneficiaries. The Paytm Bank has been stopped from certain operations by the Reserve Bank. Following this, the EPFO has advised all its field officers to accept claims associated with the Paytm Bank. In the quiz segment this month, the question is, can interest for belated payment of gratuity exceed the gratuity payable under the Payment of Gratuity Act? So do post your answers in the chat box. You would see the answer at the end of the slideshow. Moving to our next segment, across the globe, Australia has introduced a law that will grant employees the right to ignore post-work related calls and emails from their supervisors or employers. And if employees were to continue to do it, there would be fines imposed on them. Such provisions are already available in various European countries where this similar laws has been brought in. And from Australia, moving to Germany, the mandate to employ persons with severe disabilities has been brought in. The law requires employers to identify and employ disabled persons. As part of the EPF Act, international workers coming to India and going abroad both would need to be covered as an international worker under the Provident Fund scheme. As the EPFO has already entered into agreements with various countries, and now recently they have entered into an agreement with Brazil. In the case law segment this month, we get to see a judgment under the EPF Act rendered by the Supreme Court. There were two educational institutions. Both were run by one society. The question came about as to whether they could be treated as one, because if they were treated independently, they didn't have the number of required employees, and so they wouldn't come within the ambit of the EPF Act. The EPF organization sought to club both the organizations and say that there is commonality in ownership, there was financial integrity, and therefore both establishments should be treated as one. The Supreme Court agreed with the Employees Provident Fund organization and held both the organizations were in the same premises with common ownership and financial integrity, and therefore the action of the Provident Fund organization in this regard was in consonance with law. The next is a prosecution under the Factories Act, claiming that the company is covered under the hazardous process. The High Court quashed the prosecution, saying that proper cognizance had not been taken by the criminal court of the offense, and also said that the complaint lacked various essential details and it was insufficient, and quashed the prosecution against the employer, saying that there is no reason given as to why there was a prima facie case against the accused persons. In the Lex Posh segment this month, we get to see there was an amendment bill that was being introduced, wherein the limitation period was sought to increase. That is, the Act at the moment requires the women employee to give a complaint within 3 months. Now they seek to extend it up to 1 year. Similarly, to delay in filing as well. And lastly, the bill also proposed to omit the conciliation process that is there. This is only a bill stage. It was not passed in any of either the Rajya Sabha or the Lok Sabha. Given that the last of the parliament sessions has already concluded before the elections to be held sometime later in the year, this bill, unless reintroduced, would not resurface again. But we thought such a bill was introduced and should be brought to the notice of our viewers. So, taking up the knowledge corner on retrenchment compensation and quantum of retrenchment compensation.
Sir.
Yes.
Sorry to interrupt. We are unable to hear your voice. We already a lot of comments are coming in chat. Can you please check your audio once?
Thank you. Okay. Let me see what.
Sir, can hear voice, but it is slow.
I'm not sure why, but is it better now?
For me it is okay.
Okay, thank you. So moving on, we already spoke about retrenchment in the last month segment, and we would be doing some more on the law of retrenchment in the next month as well. This month, we are looking at how the retrenchment compensation is to be paid. In fact, there was no provision for a compensation till 1953. And then it was brought in subsequently in 53, and then in 76, there were certain changes with regard to 100 more workmen seeking permission from the government. So the retrenchment compensation, what is it? Two basic fundamental things. One, the person should be a workman. Second is he should have put in 240 days in previous 12 calendar months. It could be any 12 months. It doesn't need to be a calendar year. Just the preceding 12 months, they need to have put in 240 days. Then, in the event of a retrenchment, the employee would be entitled to 15 days of average pay for every completed year of continuous service or in part thereof. And what do we mean by average pay has also been defined. So the monthly paid workman, it will be you take the last 3 months and then average it out. And let me be clear here. It would be on earnable salary or payable salary. So in the last 3 months, if an employee had come only for 10 days or 15 days, it doesn't matter. If he had come for a full month, what he would have been entitled, that should have been taken. Similarly, for weekly paid and daily paid workmen as well, you have what is the average pay to be taken. There have been questions on whether it's only the basic pay and DNS allowance should alone be reckoned. No, the definition of wages in 2RR of the ID Act includes various components like basic wages, DA, house rent allowance, and it also includes medical attendance allowance, traveling allowance, and commission. So the definition under the ID Act is quite wide. Being so, it is certainly not open to you to take only basic and DA for the purposes of ID Act. Any ID Act provision requires you to take the gross wages. Maybe certain components which are not uniform, universal alone can be excluded. But when I mean such, I mean conditional payments like attendance related or production related incentives. Maybe those could be excluded, but the rest, any type of allowance would need to be reckoned for the purposes of retrenchment compensation under the Act. Overtime wages to be taken? No. When you do the 3 months average for monthly rated, you don't need to take overtime wages. It is something that he's earned in addition to his regular employment. So when you do the last 3 months average, you don't need to take overtime wages. What should it be divided by? So if it's 26 days as in Gratuity Act, or if it's February, could it be 29 days, or 30 days in April, or 31 days in March, or whichever month? The answer is you do an average and you take 30 days by which you divide it. So last 3 months you take and then you divide it by 30. Similarly, for a daily wager, we already said how you would need to do the calculation as well. Basically, if you just take the daily wages over the last 15 days and then take it up, it should be there. The next question is, when should I pay the compensation? So the compensation is payable on the date the retrenchment takes effect. So if you have to inform the employee in advance, so you're going to inform him today itself, your employment is going to come to an end on 31st March, and you inform him today in February itself, it is sufficient if you pay him before 31st March. Though the information is passed on today, it would be sufficient if you were to convey to the employee before. Is it somewhere? Sorry, my internet is again failing. So this question came about in one of the judgments on where 55 employees were sought to be retrenched by the government. Prior communication was given to them in this regard. And they said still, but the Supreme Court said the compensation 1 month's time is to be given so that he finds an alternate employment, and similarly compensation is to spend searching for another employment during that period is for his sustenance and as well as a reward for the work he has done. But it said that if it is paid before the retrenchment, that is sufficient. And when you give the notice, it is not required you need to pay it. Only, or you need to pay notice pay instead of giving the notice. Similarly, another case of where question came is the notice to be given under this act is mandatory, and the Supreme Court has said it is not mandatory. So these are a few things that we thought we'll touch upon on the retrenchment compensation. We would be continuing next month as well on the subject of retrenchment in our knowledge corner. The answer for the quiz question that was posed, interest cannot exceed the gratuity payable under the Payment of Gratuity Act. The complaints calendar for the next this to the participants, the PPT would be shared, and you could see the different things to be done. Please do join us again at 4 p.m. on 30th March for the March 2024 updates. Thank you all. Thanks for joining. Have a nice evening.
Thank you, sir.
Thank you.
Yeah,